This is lecture 13. This will be a brief introduction to forensic psychology. Reminders and announcements. Since I've done away with the modules function on Laulima, the weekly readings and videos can be found in the resources tab of Laulima in the week 13 folder. Homework 13 can be found as usual in the assignments, tests, and surveys tab, and then of course forum 13 is in the forums tab. If you are looking for old PowerPoints, like PowerPoints from when we were doing the modules, those the modules tab is still available on Laulima. I just moved it closer to the bottom of the toolbar so that it won't get in the way or be confusing.
We're going to cover the section on major activities of forensic psychologists. Forensic psychology in general is the application of psychology to the law and legal profession. Forensic psychologists have a range of responsibilities, but typically provide testimony and expertise in legal cases. So some main activities of forensic psychologists is to serve as an expert witness, to be involved in criminal and civil cases, help with domestic issues, help with protecting the rights of patients, predicting dangerousness or violence risk, psychological treatment for forensic cases, and as well consultation. But we are going to cover just 3 of these 8 activities: expert witness, criminal cases, and predicting dangerousness. You're probably familiar with the idea of an expert witness, which is someone who provides expert testimony in a court case. In the case of psychology, an expert witness would help the court to understand and evaluate evidence related to psychological functioning, and this could be psychological functioning of the defense or the prosecution, depending on the court case. They offer opinions based on psychological expertise, so typically this would be somebody with a PhD or a PsyD, sometimes as well psychiatrists. And the judge has a final decision on what expert testimony is admissible. So the judge still is deciding to what extent the expert witness can provide a certain testimony. And evidence from the expert witness should be reliable, relevant to the case, helpful for the case, and fitting for the scenario. Clinical qualifications include a high level of education and training, as I mentioned before, relevant experience. So this is definitely an expertise within psychology. Not any psychologist can sit on the stand and provide and work as an expert witness. Typically, people in forensic psychology will have at least some background in research and publication on forensic issues, a deep knowledge and application of the principle, and there are special tests and measurements, so special assessments that are used in a forensic setting, such as tests of malingering or like falsifying or exaggerating symptoms. We have some ways in forensic psychology of not 100% determining, but indicating whether somebody may be exaggerating reported psychological symptoms. A psychologist serving as an expert witness has to be prepared for cross-examination, which can be rather aggressive. So the psychologist or providing expert witness should be prepared, should be very honest and admit any weaknesses in the assessments, in psychology's ability to predict violence, for example. They shouldn't try to overstate the ability of forensic psychology to predict people's behavior or explain people's behavior. They should talk in meaningful terms, so not in psychobabble, but in terms that a regular person without psychological training could understand. Listen carefully for the wording of questions to answer the questions precisely, and often forensic psychologists serving as expert witnesses find that there's a lot of pressure to speak quickly and immediately and kind of have an answer on hand, but it's recommended that a forensic psychologist serving as an expert witness takes time to think and really is careful about the words that they choose. Psychologists working with criminal cases will often find themselves in cases where it's trying to be determined if an individual was so mentally ill at the time of committing a crime, that they may not be responsible for that crime. And this would be called an insanity plea, or NGRI, not guilty by reason of insanity. The criteria for this varies by state, but for the most part, it means that a person was committed a crime, but may not have been in a place to understand that what they were doing was wrong, or not even knowing what they were doing. So I worked in Hawaii State Hospital, which is in Kaneohe, as a practicum student for a year, and they have a lot of cases there. It's technically a state psychiatric inpatient hospital, but all the forensic cases get sent there, so all of the not guilty by reason of insanity cases will end up in Hawaii State Hospital. So a lot of times it's people who were in a state of such active psychosis, for example, that they didn't know what they were doing, or they had such strong delusional content that they were working within that delusional content and weren't in touch with reality. So sometimes people will think that to save the world, they have to kill a certain person, so there may be an attempted murder charge, but this person was operating outside of reality. Other things, people might have strong delusions about members of their family trying to kill them, or a range of reasons. So it's not as common as the media would have you think, that somebody in active stages of psychosis or other serious mental illness try to hurt other people, but in those cases there is a mechanism within our legal system to not necessarily hold that person responsible for what they've done. There's a pretty low success rate in general of NGRI, although I've heard that Hawaii has a relatively higher rate of allowing NGRI pleas. The burden of proof in this case is on the accused, so it's necessary for the defense to determine, or the defense to prove that the person was not guilty by reason of insanity. This is usually done through a series of psychological tests performed by an expert. In the state of Hawaii, a person who wants to enter an NGRI has to go through 3 assessors. So they have to be assessed by 3 individuals, forensic psychologists or psychiatrists, who are experts on assessing people for insanity or competency to stand trial, which I'll get to next. Importantly, insanity plea is a legal term. It's not medical or psychological, so there's no diagnosis of insanity. Insanity is not a word that we use in psychology, or at least not with any kind of meaning. The term insanity has no psychological validity or power in the field of psychology. So competency to stand trial is another aspect of the legal system in dealing with people with especially severe mental illness, and this is based on the fact that if a person is going to stand trial for a crime that they have allegedly committed, they need to be in a mental state where they can participate in their legal defense. So they need to understand the charges against them, understand the role of the judge, understand the role of their lawyer, understand kind of the decisions that they have. So if they want be in a mental state where they could decide to take a plea deal and not be under coercion. So often, this is also really common in Hawaii State Hospital, that somebody is receiving inpatient psychological treatment because they need to get to a place where they're able to understand these charges against them. And a lot of times that is, again, someone who's experiencing psychosis and needs to be stabilized to the point where they can get back in touch with reality enough to understand what's going on and be able to participate in their legal defense. It is more common than an insanity plea. Often people who are undergoing treatment in order to regain competency to stand trial are going to be entering NGRI pleas. And there are assessments for determining if somebody's competent to stand trial, which is essentially a lot of times just kind of asking people if they, like, what are the function of the different people in the courtroom. Somebody who is experiencing psychosis and even somebody who's experiencing delusions and hallucinations can still be competent to stand trial. They just need to understand enough about the courtroom to participate. And so there are interventions, for example, even like classes at Hawaii State Hospital, teaching people about the courtroom and about the different, about their place in the legal system in order to help them regain competency. The final role of forensic psychologists that we're going to talk about is predicting dangerousness, which typically means predicting violence risk in patients. So we talked in the last section about the Tarasoff case, in which a young man had threatened that he was going to kill his girlfriend, and the therapist was found to have not responded adequately to this threat. And this is a problem in general because psychologists do have this responsibility to inform if they think that there's a risk for violence and there are a high risk for violence in their clients. How do we know what a high risk is? Violence risk is highly overpredicted in people with psychological problems, especially certain psychological problems like autism and psychosis or schizophrenia. In part, this is due to sensationalization by the media. In part, it's due to the confounding factors of mental illness and substance use. So substance use does increase people's risk for violence. There are assessments that exist that help us to predict the likelihood of violence risk, but notably training is required to do these assessments. So it is often the role of a forensic psychologist to provide, to be an expert in determining whether somebody may be at risk for violence. So there are some guidelines for accurate violence prediction. One of the guidelines is that different violent acts have different predictors. So aggravated assault in the context of a robbery may have different predictors than violent sexual assault, for example. The single best predictor of future behavior is past behavior. And this is a basic psychological principle that has been found even outside of the field of violence risk. This is just a kind of a psychological truism that somebody's historical data on an individual client is the best means by which to predict how they might act in the future, which isn't to say that people should always be held, should never be able to kind of get past things that they've done when they were younger or in their past, but in terms of just actuarial prediction of what might happen in the future, we know this to be a good predictor. As well, certain circumstances or settings or client characteristics are known to predict violent behavior. Again, by no means does this mean that a person is going to be violent because they have one or more of these characteristics. It's just characteristics that are more associated with violence. So one, as I mentioned before, is substance abuse, which is a big predictor. So people lose their inhibitions and may be more emotional when they're using substances. So people who may not otherwise be at high risk for violence can certainly be at a higher risk for violence when substance is involved. Male gender is associated with a higher risk for violence, which again by no means says that all males are violent. It's just statistically males are a little bit more likely, a bit more likely to be violent. As well, antisocial personality traits such as callousness and lack of remorse. It's important to be, as I have kind of already said, important to be careful using demographic information to make assumptions about people in terms of violence risk. So these are just things that can be taken into consideration, but they can also be abused. So for example, violence is overpredicted in clinical settings, and we know as well in beyond clinical settings, such as in a police force, violence is overpredicted in Black or African American men, and appears to also be underpredicted in white women. So people don't expect women in general to be violent. This is more so the case for white women, and may have created an unfair bias in terms of different people with different demographic factors being assumed to be more violent. Okay, and that's it. We are done with the content of this course right now. I really enjoyed having you guys in class, especially the thoughtful responses to homework. A lot of you really took the material and ran with it and came up with some fascinating ideas and thoughts and questions. So I really enjoyed that, and I kind of wish this could have even been an in-person course. I wish you could have benefited from some of the feedback and questions of some of your fellow students, but that's just the nature of an online class. If anyone's considering applying for graduate school in clinical psychology, there is an appendix in your book with some advice. That's decent advice. It's starting on page 562. I'm also very happy to connect anyone with additional resources. There's some websites that can be really helpful, as well as people in the field who make decisions about clinical psychology graduate admissions. So I'd be really happy to connect anyone. As well, if you're considering a field outside of clinical psychology, but somewhat related, where I might have colleagues or friends, such as psychiatry, social work, psychiatric nursing, I would be very happy to connect you with colleagues who can offer advice in your career moving forward.